Welcome back to LexTalks, your starting point for understanding Indian legal concepts.
That's right.
Today, we're diving deep into negotiable instruments.
Always a fascinating topic.
Absolutely, these aren't just pieces of paper, right?
No, not at all.
They're powerful tools in the world of finance and commerce.
Exactly. Think of them as like contracts, promises to pay,
Okay.
but with a special twist,
Right.
they can be easily transferred,
Oh, interesting.
almost like cash,
Hmm.
making them essential for smooth business transactions.
Okay, so let's unpack this.
Sure.
What exactly makes an instrument negotiable under Indian law?
Well, the magic really lies in that word negotiable,
Okay.
meaning transferable.
Right.
But
Yeah.
it's not as simple as just writing an IOU on a napkin.
Right, it has to meet specific criteria.
Exactly. It has to meet specific criteria laid out in the Negotiable Instruments Act of 1881.
Of course.
For starters, it has to be in writing,
Okay.
a formal document, whether it's typed, printed, or handwritten.
So no verbal promises.
No.
Or scribbles on random scraps of paper.
Nope, those won't do.
Got it.
And it must contain an unconditional promise to pay a specific sum of money.
Unconditional. Okay.
No ifs, ands, or buts.
Mm-hmm.
Just a clear commitment to pay.
So a note saying, I promise to pay you X rupees after I win the lottery wouldn't cut it.
That's right. That wouldn't cut it as a negotiable instrument.
Okay.
The promise has to be certain and absolute.
Makes sense.
Then it needs to be signed by the person making the promise,
Right.
known as the maker,
Okay.
and clearly identify who should receive the payment, the payee.
Yeah, you need to know who's on the hook for the money
Absolutely.
and who's entitled to collect it.
Exactly.
Okay.
And there's another crucial aspect.
Right.
The instrument must be payable on demand or at a fixed or determinable future time.
Right. So there's a timeline involved?
Yes, this ensures clarity on when the payment is due,
Okay.
making it reliable for business transactions.
Now, I remember from my classes that there are different types of negotiable instruments, each with its own unique features.
That's right.
Can we delve into those?
Certainly.
Huh.
The Act outlines three main types: promissory notes,
Okay.
bills of exchange, and checks.
Right.
Let's start with promissory notes.
Okay.
Think of them as direct promises to pay.
So if I lend money to a friend and get them to write a promissory note,
Yes,
that piece of paper represents their legal obligation to repay me.
precisely.
Okay.
A promissory note involves only two parties:
Oh.
the maker who promises to pay and the payee who is entitled to receive the payment.
Got it.
It's a straightforward acknowledgement of debt.
Okay, that's pretty clear.
Good.
What about bills of exchange?
Okay.
How are they different?
Bills of exchange involve three parties
Okay.
and introduce a bit more complexity.
All right.
Here, someone called the drawer
Okay.
orders a second party, the drawee,
Uh-huh.
to pay a specific sum to a third party, the payee.
So it's like redirecting a debt.
Exactly.
Like, let's say I'm the drawer and you're the drawee. I owe money to a third person.
All right.
So I issue a bill of exchange instructing you to pay that person directly.
Exactly.
Oh,
It's
yeah.
commonly used in trade,
Okay.
where someone might owe money to a supplier,
Ah,
but wants to pay using funds owed to them by a customer.
right.
The bill of exchange facilitates that transfer of obligation.
That's fascinating.
It is.
So what's the catch?
Well-
Does the drawee have to automatically accept this order to pay?
Not quite.
All right.
The drawee needs to accept the bill of exchange
Right.
for it to become legally binding.
Hmm.
That acceptance signifies their agreement to pay the specified amount on the due date.
Okay. I'm starting to see the nuances here.
Good.
And finally, we have checks.
Yes.
Those seem pretty straightforward.
They might seem that way, but checks are actually a specialized type of bill of exchange under the Act.
Okay.
They are always drawn on a specific banker
Hmm.
and payable on demand.
Ah, so when I write a check,
Mhm.
I'm essentially instructing my bank to pay the specified amount to the person named on the check.
Precisely.
Okay.
It's a bill of exchange with those two added features:
Yeah.
drawn on a banker and payable on demand.
Wow. This is making the seemingly mundane world of checks seem much more intricate.
I know, right?
I'm sure our law student listeners are appreciating this deep dive.
Absolutely. And we've only just
I
begun.
know, this is great.
Understanding these basic types of negotiable instruments is crucial
Yes,
for anyone venturing into the world of finance, commerce, and law.
for sure.
These instruments are like the gears that keep the wheels of commerce turning smoothly.
And just like gears,
Yeah.
it matters how they mesh together.
Exactly.
We talked about these instruments being transferable, but how does that actually happen?
Right.
What's the legal mechanism that allows them to change hands?
That's where the concept of negotiation comes in.
Okay.
And it's really the heart of what makes these instruments so powerful.
Right.
Negotiation essentially means transferring the rights to an instrument to someone else.
Okay. And it's done through two key actions, endorsement and delivery.
Okay, break that down for us.
Sure.
What exactly is endorsement?
Endorsement is essentially signing the instrument,
Okay.
usually on the back.
All right.
And this signature can be a powerful tool.
Okay.
It signifies the transfer of rights from one person to another.
So imagine I have a check made payable to me,
Yes.
and I want to give it to you.
Okay.
I sign the back, write pay to expert speaker, and hand it over.
Uh-huh.
Now you have the right to cash that check.
Exactly. It's like signing over the rights to the instrument.
Okay.
And the cool thing is,
Yeah.
that same check could have changed hands multiple times before reaching you. Each time, the previous holder would endorse and deliver it to the next person, creating a chain of ownership,
Right.
documented right there on the instrument.
It's like a paper trail of financial transactions.
Exactly.
But what if I just sign my name on the back without specifying who it's for?
Okay.
What happens then?
That's called a blank endorsement.
Okay. And it makes the instrument payable to the bearer,
Okay.
meaning anyone who physically possesses it can cash it. It's like making it as good as cash.
That sounds risky.
It is risky.
What if I lose a check endorsed in blank?
That's why it's generally safer to use a full endorsement
Okay.
where you specify the person to whom you're transferring the instrument.
Right.
It adds a layer of security,
Yeah.
ensuring only the named person can cash it.
Makes sense. Are there other types of endorsements?
Absolutely. Let's say you want to add restrictions on how the instrument is used.
Okay.
That's where a restrictive endorsement comes in.
Okay.
For example, you could write, pay to expert speaker for deposit only. This prevents the person from cashing the check. They can only deposit it into their bank account.
Smart. It's like adding a safety lock on those funds.
Exactly.
What other interesting endorsements are out there?
We have the sans recourse.
Promissory recourse. Okay.
Let's say you're simply passing an instrument along without personally vouching for it.
Right.
With a sans recourse endorsement, you're disclaiming your liability.
Okay.
If the original maker doesn't pay up, the holder can't come after you.
That's a good strategy if you're acting as a middleman in a transaction.
Yes.
So we've covered blank, full, restrictive, and sans recourse endorsements.
We have. There's also the partial endorsement,
Okay.
but it's generally not allowed under the Act.
Right.
Someone might try to transfer only a portion of the amount on the instrument,
Right.
but a negotiable instrument must be negotiated for its full value.
Ah, so you can't split it up like a pizza.
Right.
It has to be transferred as a whole.
Exactly.
I'm seeing how these different endorsements add layers of complexity and strategy to these transactions.
They do.
And each endorsement becomes part of the instrument's history.
That's right.
If there's a dispute, the court will examine this chain of endorsements to determine the rights and liabilities of each party involved. It's like a financial detective story unfolding on the back of a check.
I like that.
But what about the holder of these instruments?
Okay.
Do they have any special legal protection?
That's a crucial point.
Okay.
The law distinguishes between a simple holder
Okay.
and a holder in due course.
Okay, what's the difference?
A holder is simply anyone in possession of the instrument.
All right.
A holder in due course, however,
Yeah.
has additional rights and protection under the law.
So they're presumed to have received the instrument in good faith,
Yes,
for value, and without knowing about any problems with it.
precisely.
Oh.
That good faith element is crucial.
Right.
If you find a lost instrument
Oh, yeah.
or receive it under suspicious circumstances, you might just be a holder, not a holder in due course.
Right.
This distinction can make all the difference in a legal dispute.
So if someone tries to challenge my ownership of a negotiable instrument,
Yes.
it's advantageous for me to be considered a holder in due course.
Exactly. It gives you a stronger legal standing.
Okay.
However, this presumption can be rebutted.
All right.
If someone can prove you knew about a problem with the instrument
Right.
or didn't receive it in good faith, then you might lose that privileged status.
It's like a legal balancing act,
Yes.
ensuring the smooth flow of transactions while also protecting against fraud or injustice.
Exactly.
Okay.
And to further safeguard transactions,
Yeah?
the Negotiable Instruments Act includes certain legal presumptions.
Okay.
These assumptions help streamline court cases
Hmm?
and clarify who needs to prove what.
Presumptions, like assumptions built into the law itself.
Yes.
Tell me more.
One key presumption is that every negotiable instrument was created for a valid reason,
Okay.
a genuine debt or obligation.
Okay.
So if someone presents a promissory note in court, the law assumes it's legitimate unless proven otherwise.
So it's not up to the person holding the note to prove its validity.
Yeah.
It's on the person challenging it to prove there was no real debt behind it.
Exactly. That shifts the burden of proof
Okay.
and discourages frivolous lawsuits.
Makes sense.
Another crucial presumption is that the holder of the instrument is a holder in due course, as we just discussed.
Right.
This streamlines transactions by assuming good faith unless there's evidence to the contrary.
These presumptions seem to act as safeguards for everyone involved,
They do.
ensuring a level playing field
Right.
and reducing unnecessary legal battles.
Exactly.
Okay.
And remember, while these presumptions exist,
Yeah,
the court always examines the specific facts of each case.
of course.
These presumptions are just starting points,
Mhm.
and evidence can be presented to challenge them.
So it's not just about having a piece of paper.
No.
It's about understanding the context, the intent, and the entire story behind that instrument.
Absolutely. And that's why meticulous record keeping is crucial in any transaction involving negotiable instruments.
Okay.
Having clear documentation of dates, parties, amounts, and endorsements can be invaluable in a dispute.
It's like building a legal fortress around your financial interactions.
That's a great analogy.
But even with the best precautions, things can go wrong.
That's true.
Sometimes a negotiable instrument is dishonored.
Yes.
The person obligated to pay refuses to do so.
Right.
Dishonor. That sounds serious.
It can be.
What are the implications?
Dishonor can occur with any type of negotiable instrument.
Hmm.
The consequences can be severe,
Okay.
ranging from civil lawsuits to even criminal charges in some cases.
Wait, criminal charges for not paying a debt?
Yes. In India, dishonoring a check due to insufficient funds is considered a criminal offense
Is that really?
under Section 138 of the Negotiable Instruments Act.
So it's not just a financial matter.
No.
It can land someone in legal trouble.
Exactly. That's how seriously the law takes these instruments.
Wow.
They're meant to be reliable tools of commerce,
Right.
and dishonoring them disrupts that trust.
This deep dive has been an eye-opener.
Good.
I'm starting to see these instruments as more than just pieces of paper.
Me too.
They are contracts, tools, and even potential legal weapons.
That's a great way to put it.
And while we've covered a lot, there's one unique aspect of negotiable instruments in India
Yes.
that we need to discuss.
That's right.
Oh, this sounds intriguing. What is it?
It's a traditional instrument called a hundi.
A hundi.
Yes.
Sounds almost mythical.
It does have a long history in India,
Mm-hmm.
often operating outside the formal banking system.
Interesting.
And it's still used in certain business communities today.
So while they share some similarities with bills of exchange,
Yes.
they have their own unique characteristics and customs.
Exactly. Think of it this way. A hundi is essentially an unconditional order in writing,
Okay.
made by one person directing another person to pay a certain sum of money to a third person.
Okay.
It's like a personalized financial promise backed by reputation and relationships.
I can see how trust plays a huge role here.
It does.
But if hundis aren't formally defined in the Negotiable Instruments Act,
Right.
what rules apply to them?
Good question.
How are they governed?
That's where things get interesting.
Okay.
Hundis are primarily governed by local customs and usages, often passed down through generations within specific communities.
Wow.
There's a strong element of oral tradition
Right.
and established practices.
It's like a parallel legal system within a legal system. Fascinating.
It is.
So it's not just about the written document.
No.
It's about the unspoken agreements
Yes.
and the network of trust that surrounds it.
That's a great observation.
So the reputation of the parties involved is paramount.
Absolutely.
The drawer of a hundi needs to have a solid credit history
Right.
and a strong network of trust within the community.
That's right.
So it's like a social credit score,
Yeah.
but built on real-world relationships and transactions over time.
Precisely.
And to add another layer of security, there are often intermediaries involved,
Yes.
known as hundi brokers.
That's right.
These brokers act as guarantors or facilitators, vouching for the credibility of the parties.
Yes.
That makes sense. It's like having a trusted third party
Yeah.
who can verify the legitimacy of the transaction
Uh-huh.
and the trustworthiness of the individuals involved.
Exactly.
And even though we live in an age of digital transactions and sophisticated banking systems,
Right.
hundis continue to thrive in certain sectors.
They do.
It speaks to the enduring power of tradition and trust-based systems,
Yes.
especially in a country as diverse as India.
Absolutely.
For legal professionals,
Yes.
understanding Hundis is crucial.
Absolutely.
Imagine you're dealing with a client or a case
Right.
that involves these traditional instruments.
Uh-huh.
You need to navigate both the formal legal framework of the Negotiable Instruments Act
Yes.
and the nuanced realm of custom and practice surrounding Hundis.
You got it.
It's like having an extra tool in your legal toolkit,
It is.
allowing you to bridge the gap between the formal
Right.
and informal aspects of financial transactions.
Well, that's a great way to put it.
This brings us to a broader point.
Okay.
Whether we're talking about formal instruments,
Right.
like promissory notes and checks,
Mhm.
or traditional ones like undies,
Yes.
negotiable instruments are deeply woven into the fabric of commerce.
You really are.
They are the threads that connect businesses, individuals, and financial systems.
Absolutely.
This deep dive has been an incredible journey,
It has.
taking us from the basic definitions
Right.
to the intricacies of endorsements, presumptions, dishonor,
Yes.
and even the fascinating world of Hundis.
Such a rich history.
It's been a reminder
Yeah.
that law is not just about statutes and courtroom dramas.
No, not at all.
It's about understanding the real-world transactions,
Right.
the relationships and the instruments that shape our economic landscape.
Well said.
And remember,
Mm.
the world of negotiable instruments is constantly evolving.
That's true.
New technologies,
Mm.
digital innovations
Yeah.
are reshaping how we conduct financial transactions, for sure. As legal professionals, we need to stay informed and adaptable to navigate this dynamic landscape.
Absolutely. We can't just rely on what we learned in school.
On that note, we want to thank you for joining us on this deep dive into the world of negotiable instruments in India.
It's been a pleasure.
We hope you found it informative,
Yeah.
engaging,
Uh-huh.
and perhaps even a little awe-inspiring.
Definitely a lot to think about.
Don't forget to subscribe to LexTalks
Yes, please do.
for more explorations of Indian legal concepts, simplified and demystified.
We'll see you next time.
Until next time, happy studying.